Okay, let's welcome our audience. Welcome to the Work Comp Weekly podcast. I am Dan Mora, your host, and directly across from me,
co-host here, Frank Smithson.
How's it going, Frank?
It's going good.
Yeah, nice weekend.
Yep, pond sucks. So everybody that's aware of that, still got a leak, and it's killing me. I'm starting to get pretty deflated. But otherwise, I went and saw the Perseid meteorite shower, which was lackluster, to tell you the truth. I saw probably like 10 shooting stars. I was supposed to be seeing 50 to 100 an hour. That did not happen.
Really?
Yeah.
I saw the Barbie movie. It was good.
Oh, that's pretty cool. Yeah, I want to go check that out. I haven't.
It's good. It's worth it.
I was sick when my family went and saw it, but I was ready to dress in all pink for sure.
Yeah, we went as a family. It was a good movie.
Did you guys dress up?
Some of our family did.
Okay.
I have a pink shirt. I didn't want to wear it.
Boo.
So some news quick hits here. The DWC proposes an updated treatment guideline. This is specifically for hand, wrist, and forearm disorders. This is a news article from Work Comp Central on August 4th. There is a public comment hearing September 15th. So anybody that wants to attend that, there's your information.
I'm curious from our audience too, when these changes come about, you know, how easy it is for them to deal with ratings and things of that nature. Yeah, feel free to comment on that. That'd be interesting to hear your guys' perspectives.
Yeah.
I have another news tidbit here about Sonoma County. This is from Property Casualty 360. The Sonoma County District Office received a $339,000 grant from the California Department of Insurance that will be used to investigate and prosecute cases of workers' compensation insurance fraud. Specifically, the money will be deployed to thwart instances of medical provider fraud, employer premium fraud, and claimant fraud, all of which drive up workers' compensation costs. So I'm curious if our audience out there is aware of how much money is being spent on fraud in their local counties. If there's any kind of, singular source where you can understand that. I know a lot of money has been in Orange County. It seems like that's been a big thing. So, and $339,000 doesn't sound like a whole lot to fight this. Anything's better than nothing, I'm sure.
My understanding of how this operates is that the district attorney can apply for this grant at the Department of Insurance, and so the Orange County, they figured out how to do that, and then got super active. So it looks like Sonoma's doing the same thing. What I think is funny and interesting, 339,173. It's a very exact number. I mean, where did that come from?
Sure.
Anyhow, last tidbit news here. Was from Work Comp Central as well. So August 8th. And this is just a piggyback off of an NBC article covering, the negatives about workers' compensation right now, specifically federal workers' compensation. It's talking about just the delay and it's pretty crazy. So the FECA program received 182,000 new injury claims in fiscal year 2022, according to data provided by the Labor Department. That represents a 62% increase over 2013 when it received 112,807 claims. Mm-hmm. And so there's a presidential aspect of this as well, and a union aspect of this as well. Interesting, right?
I'm curious how much the actual presidents have to do with any of this, but I guess last term it under Donald Trump it went down.
The number of staff,
and then now Biden's increased it. 281 new claims examiners and 55 more medical treatment adjudicators. Regardless of that, it's still lower than 10 years ago.
Wow.
Staffing levels were higher. So there's still, and this next little piece is very interesting. I'm not sure how they were able to get union representatives to even quote this, but it says 2 union representatives, each working for a different federal agency, said the problem is so difficult that they sometimes advise members to file claims under their personal health insurance first before reporting workers' comp. That sounds like fraudulent to me. Like if it's workers' comp, it seems like it should be Like, you can't lie that it's not. But basically, there was a story. A guy hurt his knee in March of 2022, and all of his doctors are telling him, like, if you don't get this thing fixed, you're going to need a full knee replacement. Oh. And it's still ongoing, like, as of right now.
Gosh.
So it's, what are these people supposed to do?
Yeah. Yeah, it's kind of my angle on universal health care, right? Yeah, when you have a government run, I hate to say it.
Anything?
You have government run benefits administration, especially medical benefits administration, speed is going to suffer, especially if it has to go through adjudication. Mm-hmm. Sad. So you get hurt.
Don't get hurt.
Don't get hurt.
Don't get hurt.
If you do, make sure you get treatment. And I think that this. I don't know if it's illegal, but I don't know if it's wrong that these union representatives are pushing their people to.
Wrong and legal are two different things. I mean, if you need to get care, get it any way you can. I mean, don't listen to your union reps, not me.
Okay, so our main story here, the WC court orders. So this is the second. What do I have it here? It's the second district appeal, the District Court of Appeal, California Second District Court of Appeal. Tuesday, this was August 2nd, said that the Workers' Compensation Appeal Board can't grant petitions for reconsideration for the purpose of further study, simply to satisfy a requirement to act within 60 days.
They're doing boilerplate. This is a study.
Right. Yeah.
And then it sits.
This is in response to a long history of the WCAB when receiving a petition for reconsideration. When they do receive a petition for reconsideration, their job is to respond, or I think it's act as the official terminology, within 60 days. These numbers are pretty damning. The number of grant for study issuances, the court said that from 2015 to 2019, the WCAB issued grant for study orders in about 19% of cases. That increased to about 38.5% of cases in 2020 and 2021. As of November 2021, there were 543 cases awaiting a final decision, in which the WCAB issued a grant for study order between October 1st, 18 and October 1st, 2021. So there was then, I think it was last year, I think it was in 2022, I actually know the attorney that filed this case. So the court in Michelle Early et al. V. WCAB also held that while the board must issue a reasoned decision on whether reconsideration is appropriate within 60 days, it is not required to issue a final ruling on the merits of a dispute within 60 days. So the appeals court said grant for study orders for each of the petitioners arose in different situations with different timelines, but the WCB orders were exactly the same in each case. So this is
that's basically highlighting the boilerplate. I think it sounds like a win, but the concern is what happens if they don't have the information necessary to make that decision. I think if they don't respond to it, in fact, they even go straight to denial.
That's what I understand as well.
So this is like an issue with resource.
I think so, and I'm really, this is good progress. And then the question is, like, how much will this actually improve the system? We don't want to be too much of cynics here.
What recourse of action do they have if, for example, they put in a recon and it just goes to denial because there wasn't the resource to fix it?
Right.
What happens after that? I don't know. I'm curious. If any of the attorneys out there or have had to deal with this type of situation and what the impact is to injured workers. And this is an interesting one because it kind of goes both ways. So whoever files for the recon, they're going to want their communication to move forward.
Right.
I think do remember, wasn't it that they end up having to go to trial to figure anything else out that the recon would have been able to satisfy? They then have to kind of like put it back onto the attorneys,
right?
To figure it out.
It could go to trial. It could get settled. However, either way, yeah, this is pretty good. This is a good thing to happen. We don't want to play the cynic too hard and say, what really is actually going to result in this? But we're curious. I think this is a big. To me, it highlights a couple of things, and for sure, number one, that the staffing at the state level is notoriously bad, behind the eight ball. But this highlights it, and then you get people that are really needing help and some resolution on their case.
I mean, the fact that this is now has to be like understood within a 60-day time period is going to speed things up to some degree, even if it's forced to kind of go back into trial or whatever.
Right.
At least they know immediately, and they're not waiting for wasn't it like 2 or 3 years, you said?
This early case was damning. So this was a June. It was the employer sought reconsideration of a judge's order granting reimbursement for self-procured medical treatment that the board accepted for further study in June of 2020. So this was then the suit was filed against the WCAB, I believe, in 2022. I'm pretty sure. So 2 years that this that it was hanging out there, which is pretty sad.
It's kind of, we just talked about a little blurb in the federal courts, how they're taking forever to take action as well.
Yeah.
It seems like, the pace of the government is never good.
Yeah. So what ended up happening too is interesting. So we got a new commissioner sometime last year. And he immediately made a comment that their role was to only act. And so they were fulfilling their obligation. So this decision by the second appeal.
Fulfilling it by saying we're granting a study.
Correct.
Yeah.
Eventually, I think with this suit, what ended up happening is they probably cleared the deck. The WCB was like, okay, we got the signal. Let's go clear the deck. And possibly hoped that the case would just go away. It didn't go away. The court noted that the WCB had not issued decisions in any of the petitioners' cases at the time they filed their petition with the second DCA, but it has subsequently issued final rulings in each case. While this rendered the petition moot, the court said it can consider moot issues that are of public interest, capable of repetition, or that may otherwise escape judicial review. This issue is of this issue is of public interest and is likely to recur, the court said. The issue can also evade review if the board repeats what it has done here. Issue a final ruling after a party seeks writ review. So
I'm curious. There must be people out here that sounds like they're continuing to work on this. I wonder what is in their mind going to be able to solve these types of problems.
Yeah. I too think I would like to hear the audience, like, where the California Constitution states that workers' compensation shall accomplish substantial justice in all cases expeditiously. If the WCAB can't fulfill its obligation, if the state can't fulfill its obligation, what is going to happen to the system? I'm not the first to ask this question. I'm very curious kind of what our audience has to say about it. I'll tell you a quick story. I had a meeting with one of the CEO of one of the largest insurance companies in California, the largest at one point. I'm not sure if they are anymore. And we highlighted a problem that we were trying to solve. Doesn't really matter. But his reaction floored us all as we were in the room. He basically said, I see it's a problem, and I would like to see that problem all the way through. we don't need to solve it. We need it to become a bigger problem is basically his reaction.
Huh.
So that we suffer the consequences and change that the consequences drive the change that needs to happen.
So let's be reactive and not proactive.
Though I know, I mean, it's a valid reaction. Like, I mean,
to get government to move, I think that's what needs to happen. Unfortunately, I wish we lived in a world where they could be proactive, but if history says anything, it doesn't seem like that's the case.
Yeah.
Yeah. I'd like to hear from our audience too. How's this going to look in the future? Is it going to be the same old? More denials are going to end up happening because they just don't have the resource.
Let's wait and see, huh?
That kind of reminds me of the liens. Lean, and then now the court's getting backed up. They're like freaking out, and then of course the consequence made them take action, right?
Yeah, that's a good example.
So if let's say a bunch of these things move to denial, and then all of a sudden the courts are getting backed up with trials to handle these things that could have been, knocked out by the WCAB.
The way of the land. Then they legislate it.
Yeah, yeah.
Right on, Frank. Well, good time. Great conversation. Again, let's welcome our audience to comment, like, subscribe.
Yep. Please do.
Do all the things. All right. All right, Frank. Good talking.
Appreciate it. Have it going.
See ya.